Well, good evening, everybody. James Manson here, constitutional lawyer. By now, I think quite a number of you have probably um, seen the news on social media that the organization that I work with, we've been able to file a challenge to Prime Minister Trudeau's prorogation of Parliament that happened yesterday. That document was filed sometime this afternoon, and I would expect that hopefully we'll be getting going with that case on an urgent basis very soon. Certainly the court will appreciate the gravity of the situation. But I wanted to reach out, to explain to everybody who's interested, exactly what the case is about and what we can expect maybe going forward. First of all, the case is interesting and very important and really quite unique in our country. It never happened before. It's never happened before that a couple of litigants, and in this case, the litigants are two citizens of Nova Scotia. They have challenged the Prime Minister's advice given to the Governor General to, as I say, prorogue Parliament. That's never happened before in Canada. There have been many prorogations, and just so that we all understand, a prorogation is essentially a royal prerogative. It goes back to the days of the kings and queens back in England, back a long time ago, when the king or the queen was the boss, and they did whatever they wanted to, and they could, if they want to, suspend Parliament for however long they wanted to. And as time went on, of course, democracy took stronger hold, and then it was the Prime Minister who was able to essentially assert his power, or, well, it was always his power at that point, over the monarch in terms of when to suspend Parliament. So now what happens is the Governor General, who acts for the king or the queen, will do essentially what the Prime Minister advises them to do, and in this case, that's what happened yesterday. So there's nothing inherently wrong with prorogation. Prorogation really is a temporary suspension of Parliament, and usually what that is to give everybody a chance to legislatively reset the situation. So oftentimes what happens is the government will have a speech from the throne. There will be a direction laid out by the speaker, or pardon me, by the monarch, by the Governor General in this case. And once that legislative agenda is finished, then there needs to be a new direction. There needs to be new department instructions given, and there needs to be new, momentum established for new legislative policies, things like that. And that's normal. Yet that usually happens probably once every parliament or so. However, where it gets tricky is that you can't have it done. You can't prorogue Parliament to avoid political trouble. That's really what it comes down to in this case. Our case is remarkably similar. That's how, anyway, we will argue the point, to the case in 2019 when Prime Minister Boris Johnson in the United Kingdom, he attempted to prorogue Parliament for 5 weeks out of 8. And the timing was very, very tricky because, as you guys may recall, that was when the Brexit was coming, and they needed to have an agreement with the European Union about how to exit from the EU. And if they didn't, there could be a hard exit, and it would have been very catastrophic economically, politically, for the UK and maybe for the EU. So anyway, Prime Minister Johnson at the time decided anyway to prorogue Parliament for 5 weeks of the 8 remaining weeks leading up to the Brexit. And essentially, he wanted to avoid scrutiny from Parliament. He wanted to avoid the tough questions, avoid all of the mess in the House of Commons that was happening at the time. And so ultimately, this led to a challenge like the one that we've brought today. And the Supreme Court of the United Kingdom ruled unanimously, 11 to 0, that the exercise of the prorogation power by Prime Minister Johnson to advise, at that point, the Queen, to prorogue was unlawful. And essentially what the Supreme Court of the UK said at that point was that you can't, in the course of proroguing, you can't frustrate or prevent the ability of Parliament to oversee the government, to do its job, which is to oversee the government, to supervise the government. Because as we all know, it's Parliament that is the supreme body in a Western parliamentary system. It's Parliament, not the government. It's Parliament as an entire body that is actually the supreme body of the country. So in any event, that's what we're saying happened in this case. We are suggesting that, like what happened in the UK when Prime Minister Johnson did what he did to really frustrate the will of Parliament to supervise the government, we're suggesting in the same vein that in this particular case, the Prime Minister has prorogued Parliament in order to really gain some political advantage here. He has given us his reasons, as you all know from yesterday's press conference. The reasons are to reset, not legislative resetting, but to reset the tone or the acrimony that he's been seeing in the House. Well, there's a way to do that. It's called have an election. There's a way to do that. It's called face the opposition, have a motion of non-confidence, and have an election. That would be the democratic and legitimate way to reset Parliament. There's another issue, which is that why 11 weeks? This is an 11-week prorogation. That seems to be an awfully long time simply to have everybody's temperature cool down, to use the Prime Minister's words yesterday. And thirdly, there's also the stated intention of allowing the Liberal Party to have a leadership race. Now, I am not speaking politically at all in this case. However, what I'm doing is I'm speaking from a legal point of view. And as the UK said, the Supreme Court in the UK said, there must be a reasonable justification. And a Liberal Party, a political party's internal leadership race really has nothing to do with the business of the government. That's a party matter, not a government matter. And it's also certainly not something that all Canadians ought to worry about, particularly, again, in these times of turmoil when we know President-elect Trump is making noise, and that should be of concern to, in my view, all Canadians. And so in my client's view, in the applicant's view in this case, Parliament needs to be in session. Parliament needs to be ready to deal with what's going on. And to prorogue Parliament at this time, a few days before January 20th, when President Trump will take office, is dangerous, potentially. There needs to be a Parliament there to, do whatever Parliament might do. Perhaps ratify an agreement, perhaps who knows what. But any event, we say that in this case, the prorogation was without a reasonable justification, and therefore it really never happened. What happened in the UK case was that essentially the Supreme Court found that the advice to the Queen was never properly given. Therefore, it never really happened. It wasn't of any real consequence. And so the UK Supreme Court decided that Parliament, in fact, had never been prorogued, and that it was free to resume sitting at the next day. So that's what we'll be asking the court, the federal court in this case, to conclude as well. If the court is sympathetic with our argument and decides to allow our application, grant our application, we would expect, again, Parliament to resume sitting at the earliest opportunity. And I guess at that point, Parliament would then decide what it would want to do in terms of confidence motions or not, responding to any American political moves that are being made or not, or otherwise conduct its own business. But that's up to Parliament, of course, not the courts, and certainly not my clients. But it's up to them, and again, all Canadians, to decide what to do going forward. So that's essentially the case in a nutshell. I hope that is of some value to you, and I will be back as time goes on with further developments. Thanks for listening. Bye.